Any mentioning up in the list? Any mentioning in the list? Item number 1, we have a 4 of 1924.
Vying for the respondent state. Must be vying for the appellant. That for the incident matter lawsuit. Where is the accused was.
So, did you look into the issue of maintainability?
Our right of Honorable Justice Joymala Bhakti and Honorable Justice Gaurav Khan. In these cases, the limitation was allowed, and after that, direction was given to me to serve the copy of the petition to the appeal court.
You're for the state.
And for this state, Lordship, respondent number 2, victim already make a party in the appeal.
Alright.
That is respondent number 2. Victim is already party in that state.
Lordship,
That's all right, but admission
Lordship,
has to be only after admission.
Lordship.
Same order, subject to that modification, strike order. Yes,
Lordship.
I'm
admitted.
grateful, Lordship. Grateful.
Lordship.
Obliged, Lordship.
Item number 2, MAT 76 of 2024.
Not yesterday.
Yes.
Yes. This that matter, not yesterday. I filed affidavit service, but it is shows that it was delivered.
My lord, I request my learned friend to serve a copy. I will update because I also filed an appeal, my lord. It will be coming in the next week.
Let's have a copy. It is submitted by Mr. So-and-so. That he shall be, you have not filed a vakalatnam yet.
No, my lord, today. only I
That
am-
he shall be filing a vakalatnam on behalf of the respondent. One or two, how many?
Sole respondent.
On behalf of the sole respondent. So it is further submitted that the respondent has also preferred an appeal against the
Challenging part of the appeal.
challenging a part of the same impugned order, the self same impugned order dated 18/11/2024, passed in WPA 361 of 2024. Stop. Let the learned counsel for the appellant serve a copy of the present appeal and applications on the learned counsel for the respondent. The learned counsel should file the vakalatnama during the day
My lord, next, in this week.
within this week, full stop. The matter is to come up in the next available circuit. Can you give the number of your appeal?
That it was supposed to. I can give during the course.
Then I can incorporate that
Yes,
both
yes.
be listed together.
Together, yes, my lord. I-
Yes, where we have said he has filed an appeal, which has been numbered as so and so. Give the number.
My lord.
And then the last you say in the next available circuit along with appeal number.
My lord, I just seek a liberty, my lord, because based on the report which we have filed, the court has passed the judgment. But this is in that appeal, independently, the report has not been enclosed. I may permitted to grant liberty to enclose the document, my lord.
The learned counsel for the appellant would be at liberty to file a supplementary affidavit, placing on record a report, relying on which the impugned order has been passed.
Obliged.
Item number 3, MAT 16 of 2022.
Lordship, in this matter, I am for the appellant, your lordship. This appeal is only for a limited purpose, your lordship. I'm just getting the brief facts of the case, your lordship. My father, your lordship, the appellant number, I'm just coming to that. Yes, lordship. Appellant number 1, your lordship, is the daughter of deceased Ganapati Muthuraman, your lordship, and I have a sister, your lordship, who is now sole defendant, your lordship, in the case, your lordship, appeal. Now, your lordship, during the lifetime of my father, your lordship, we used to reside in the same building, having separate house, your lordship. My father used to reside with my sister. Now, your lordship, during his lifetime, your lordship, he, prior to his death, your lordship, he lodged a complaint before the senior tribunal, your lordship, regarding that the appellant number 1 and 2, who is the son of law of the deceased, your lordship, is harassing the deceased Ganapati Muthuraman, lordship. And the senior tribunal, your lordship, passed an order directing me to evict from the room, your lordship.
Directing you?
To vacate the room, your lordship. And thereafter, I preferred an appeal before the deputy commissioner, who is the appellate authority. Appellate authority also affirmed the order passed by the tribunal, lordship. Thereafter, your lordship, I preferred a writ petition before this honorable court, your lordship. This honorable court, your lordship, while dealing with the writ petition, your lordship, passed order affirming the order passed by the appellate authority as well as the tribunal, lordship. But I am only affected, your lordship. Thereafter, your lordship, I filed this appeal. Now, during the pendency of this appeal, your lordship, the deceased, my father expired. So I pray before this honorable court, division bench, your lordship, this honorable court, please to grant me liberty to substitute the legal heir.
Who is this legal heir?
My sister, sole sister, your lordship. So the main crux of the matter is that, your lordship, in the impugned judgment, your lordship, one paragraph. No, only on the point, your lordship.
Even one slot and I died. Who will substitute the slot?
The prayer was allowed only on the point because of the fact of that the Indian.
What is the nature of the statute under which the
Yes,
authorities
I'm just coming on. The
What
only
is the nature of the statute under which the authorities have passed the order?
senior citizen tribunal.
We are not asking the name. We want to know what is the nature of the proceedings.
Nature is by law that the authorities directed the writ petitioner to leave the premises on that. Yes, I'm right. The authorities directed the eviction of the writ petitioner because of the complaint filed by the father.
Complaint. So it is, what is the nature? It's a civil or criminal?
It is a civil.
Civil.
It is a special enactment by law, under which by law.
There is no penal provision.
No, ma'am. Not that I know, ma'am. I can take that.
Can we see the act?
Penal provision.
Act,
No, your lordship.
Because he is claiming substitution, therefore we are.
Substitution.
Why I'll explain, ma'am.
So let us see with reference to the act. Let us see.
Can be.
Then only there is an occasion for substitution.
Substitution allowed, your lordship. That has been allowed.
Already allowed.
Allowed.
In these proceedings.
Yes, your lordship. Allowed.
Yeah, appeal is fixed for hearing.
Hearing. I'm just giving the brief fact.
Still, let us see the act. So now you are the substituted.
No, I am the appellant.
You are the LR now.
Yes, your lordship.
Then who are you?
Your lordship, I am the appellant. LR, my sister, both are sisters, your lordship. The predicament is that, your lordship. Now my father.
So in the complaint, he had not alleged anything against her.
No. Accompanying, I will come to that, your lordship, whether that
is not essentially a property dispute.
Yes, your lordship.
It is as a result of the harassment or the mistreatment that the order is passed by the authority. Therefore, we are saying the person who was the victim is no more.
No more.
Where is the question of substitution?
No.
This is something which is crossing the mind of the court. Therefore, we are being vocal. Let us see what is the position.
Why the substitution was granted, your lordship? Just come to that, your lordship. Kindly appreciate the in the impugn order passed by the learned single judge, your lordship, I place one fact before the learned
Can
single
you
judge.
please give the name of the act on a second? Sir, can you take the trouble of so that they can find it? Or we'll refer to it on the internet if a hard copy is not here. Welfare of parents and
Yes,
senior
yes,
citizens.
Senior Citizen Welfare and Maintenance Tribunal Act, your lordship. Your lordship,
There in the order itself, page 90,
order itself there.
Page 93. Act's name is mentioned.
Yes, your lordship.
last line.
It is not a property dispute. It is not a dispute relating to
Lordship,
property, not
lordship, lordship.
essentially a civil dispute in
Lordship,
that sense.
Lordship,
Although the civil rights are involved,
lordship.
but the result, it
Page
is
94, your lordship, 93, last 93 from last line, your lordship. The petitioner challenged the order dated such and such of the application under the provision of the Maintenance and Welfare of Parents and Senior Citizen Act 2007.
2007.
Plus, lordship.
Give another copy. Take a print out, take a print. Yes, so please do continue. They are giving us a copy.
Lordship.
Yes.
Now, there has been the impugned judgment, why the Honorable Court was pleased to allow the substitution application, Lordship, because Lordship, I made a point before the learned single judge that the land which has been allotted to my father is under the scheme of the government of India, which has been allotted by the administration, Lordship. And the fact is that, your Lordship, that scheme, the allotment is for the family. This was my case before the one of the
Point
point
is why we are saying it is not a property dispute.
Lordship. But the single judge
It's
has
not a property
Yes, sir.
dispute.
single judge
What is
taken
the
otherwise.
nature of the property hardly matters.
Yes,
It is the welfare of the senior citizen which
Lordship.
is paramount under the statute. Whether it is a family property, whether it is a joint property, whether it is owned by.
that only line
that
is hinging
hardly
me because
matters.
I will be in trouble while getting my claim before the
Sir,
civil court.
we are observing something which may go either way.
Lordship.
If the victim is no more, where is the question of the order surviving?
Lordship,
That
Lordship,
is another aspect.
Lordship,
So let us see what is the
Lordship.
stream of the act.
Lordship.
That is what this learned single judge has also said, that this is not a property dispute, it is
No,
only
no.
to protect the father.
No,
Where is the order? Which page?
Page 93 itself. That is exactly what the learned.
no, Lordship. No, Your Lordship. Para 15 of the impugn order is hinging me, Your Lordship.
See chapter 6, you have a copy of the act. Primary object as per the, which is explicit from the act, is maintenance. Now the nature of the property hardly matters even in the definition under section 2. It says it may be ancestral, it may be wholly owned, self-acquired, tangible or intangible, includes rights of interest in such property. Lordship. You are for the estate.
Why not? This appeal has become infructuous. The person has passed away. If there are any civil disputes, that will have to be thrashed out before the civil.
That is prima facie, that is the view.
Lordship, I'm not on that. It's true. But the only,
No, the only, yes, just give
Yes,
it.
Lordship.
We have heard you, just.
Lordship.
Just see paragraph 15 of
15,
the.
yes, Lordship. That is the thing, Lordship.
Complications are in the context of this proceeding. It cannot bind the civil court.
No, Your Lordship, it will.
Of observation of the
High Court, Your Lordship.
That, my lord, your lordships can clarify, my lord, that that is not, either way, my lord, that is an observation in the context of these.
Lordship,
We'll
Lordship,
have to
Lordship.
pursue the
This
remedy
is the only
otherwise.
thing, yes, Lordship.
Now he cannot be restrained. The victim is no more.
Lordship.
So if you have any dispute or you want apportionment of shares or whatever,
Lordship.
then you can both of.
During lifetime, my lord, taken loan for construction of the.
That we have read, he was a bank employee, he was a government servant.
Yes.
He has taken a loan, we've just gone through it.
This paying.
So therefore, you may assert these things. This is not the forum.
Lordship.
This, the only, the limited scope of the proceedings under the act is to ensure maintenance of the senior citizen, the fading institution of macro families, emergence of micro families, aging becoming a problem, the act has been passed.
Speaking, this becomes infructuous.
That is what we think all the parties are in agreement, but paragraph 15 cannot
Only for that.
stay. Otherwise,
Only for
it
that.
amounts to deciding the rights of the parties, which cannot do. We will leave it open.
Likely decided,
It appears to be.
likely decided.
No, Lord, no, Lordship.
It was not
No,
under
Your
the
Lordship.
scheme.
No, your lordship.
Just show a discussion of the scheme in the order passed by the honorable single judge.
It's
Sir,
Yes,
page 97.
and both parties were heard.
Yes. They are residing in the same property, they are lodging complaint against the senior citizen before the Tahsil. And they want now share. Primarily para section.
Even these observations, whether they exist or not, it will neither weigh in favor of the either of the parties. These observations are in favor of respondent number 2 therein.
Yes.
Who is no more.
I have taken submission.
Both are jointly possessing as of now.
No, after eviction, I have not.
You are ousted.
Ousted.
So we leave you to avail your remedies.
Yes, your lordship. That's the thing. Only that thing I want, your lordship. This observation.
Yes.
This observation. Son-in-law, no. Son-in-law, no, sir.
Oh.
I'm just getting the date. your lordship. Yeah, a sufficient application is there, your lordship. March 18th, 2023, your lordship. है ना वो ऑर्डर 1 रूल 10(2) का है वही वाला ऑनरेबल जस्टिस हरीश बैनर्जी
Settlement record on order of record.
yes sir order has been passed by the honorable
Order. Record.
settlement
Yeah.
scheme yes in the appeal it is there your lordship yes it is at page I'm just coming to that starts from page 75 your lordship appeal your lordship paper book your lordship. Record of rights is at this is the scheme and ROR record of right is at page 31 your lordship. ROR record of rights is at page 31 and this Remarks column may be seen, Your Lordship. Yes, sir, we both are not. Ganapati Muthuram. Full name of my father is Ganapati Muthuraman. But in the record, Your Lordship, Lordship. It is under the scheme. Under the scheme. No, Your Lordship. No, Your Lordship. There is no upper limit fixed, Your Lordship. In the scheme, no, Your Lordship. It's sorry, lower limit, Your Lordship. I will come to the scheme. In the scheme, Your Lordship, if Your Lordship comes to paragraph number, Lordship. Page 77. Page 77. Page 77. It's my. If Lordship comes to page 75, it starts from page 75, the scheme. In that, Your Lordship, if Lordship sees subject scheme for disposal of government land in revenue village unauthorized occupies on or before 30.
Allow us to read, please. Just allow us.
Lordship. And recently, and I can place many license copy, Your Lordship. Where is it? कम भी दिया है कम भी अभी जजमेंट है 70 इनकम ऑफ इंडिया फैमिली ऑफ इंडियन पार्ट मसाज समझा बता दो गड़बड़ नहीं करोगे
What is the basis of the conclusion in paragraph 15?
15, yes, your lordship. I will deeply obliged.
Going by the size, the plot, not by the nature of the allotment order.
That has to be, evidence has to be led.
Yes. How can,
Lordship.
maybe for the purposes of
Yes.
enforcing this, it was a correct, because the prime consideration was to ensure that he was maintained.
Lordship.
But now this cannot be relied on.
Lordship, if it comes to your lordship might clarify that those observations are in the. context.
Yes, in the context of the
Lordship,
proceedings in which it was
Lordship,
passed.
Lordship, Lordship.
And is there anything like that written by the honorable judge that this will not be
Hmm,
weighing in either favor of
Hmm.
either parties in any other proceeding?
No, lordship, that has
If
not.
that is there, then such a clarification may not be required.
No, not there. I'm not there, lordship.
What is the effect of paragraph 20?
That is because opposition affidavit reply was not filed, so therefore the court said that there is no deemed admission. Now, let's see para 16. Lordships, lordship has recorded in the backdrop of the above discussion. The order of the learned tribunal and learned appellate authority under 2007 Act stand upon.
But that is admitted that he was having 0.12 hectares. There is no dispute that.
No,
is-
there is no dispute that.
The learned single judge is only considering a challenge to the orders passed by the authorities under which act.
But he has made some, he
Those
has,
observations cannot be read out of that context. That's my point. So that neither party is prejudiced. my lord.
Lordship.
yes, neither party. should
Lordship,
be
lordship.
prejudiced.
That is my only anxiety, lordship.
Because even if these observations are left as it is, he cannot derive any benefit from, she cannot derive it. It is exclusively for the person who is no more.
Lordship. Can it be disposed of by clarifying, lordship?
All-
That
yes.
part, it will be better, lordship.
Part that
Otherwise,
counsel
lower
for
court.
the appellant
Today I got the order, but not been installed.
Mediation has failed. Report has been given.
Where council, therefore, the party.
Where is he? Today he is tired in the morning. Yesterday he was tired after 4 p.m. We thought that today you are tired in the morning.
Their clients. So I finally relieve me from this responsibility. I tried.
You have submitted a report that mediation has failed. No, no, if it is referred to mediation, then you must report whether it has failed or. Where is the order referring it to mediation? Can you give the date of the order? What is the issue?
I can't find it's sued for divorce.
Oh,
I can, I just go ahead and tell you.
an extension to file the status report, but my lords may not be necessary. I am handing over the document which has been given to me today. Manoj. What the relief that they are seeking, my lord, it is already, my lord, will see the slide. The Ministry of Home Affairs has already given the approval. Proposal has been, I am directed to refer to UT of 2024. The proposal has been examined in this ministry in consultation with Department of Expenditure, Ministry of Finance, and approval of the competent authority is hereby conveyed for creation of following 3 posts in Directorate of Law. So one of the posts have already been issued, created, and this is issued in concurrence with Department of Expenditure. Now, my lord, the further steps will have to be taken, my lord, for framing of the recruitment rules and other things. No, my lord, now after this, my lord, the recruitment rules, etc., will have to be framed, my lord. That will take some time. But my lord, otherwise, my lord, it's not a mandatory provision even otherwise, my lord. But be that as it may, we are taking steps. What the petitioner is seeking, that is being done. Now, my lord, this will proceed. I've given.
I have so your lordship, for the further process, a time bond may be given so that they may come.
My lord, because central government is also involved, my lord, we cannot today, then central government has to be issued notice, my lord. We cannot, my lord, as administration, we have limitation, my lord. We cannot. No, my lord, steps are being taken in that. Yes, ma'am. Yes, my lord. That whole process takes some time. So, my lord, for us to other people. Yes, ball is now rolling. And my lord, this involves because the UT without legislature, my lord. In each step, my lord, approvals are required from the central government. So, my lord, today, my lord, steps are being taken, but my lord, we cannot make a categorical statement that it will be done in 6 months or something like that. Yes, my lord, but this is one of the first steps, my lord. It has been the sanction for creation of the post has been done, my lord. Now, my lord, the recruitment rules, etc., have to be framed. Sir, Tulsi Lal, sir, represents. He's here. He represents the Union of India, but sir. He's showing for not even a party, my lord. Union is not a party, my lord. He's showing for. Yes. Okay. Created post. Now it's for them to do what is to be done by the local administration. No, my lord, we have to frame the recruitment. Instructions, we are taking steps, my lord. But today, my lord, to say that it will be done within a particular time frame, my lord, that will be a bit problematic.
They have to frame RR. They have to frame.
Expenditure has already given its approval, finance.
May be required, my lord. Because the group, the nature of the group B post, my lord, then UPSC approval, etc., may also be required. My lord, then grant 8 months or my lord, then if extension is required, we see.
The senior counsel representing the administration has handed over a copy of Concrete, yes.
Item number 6, CRA DB 3
My lord, in this case, my bill is appearing for the responding. I am seeking some more time to file a written opposition.
Lordship, I am for the state lordship. It's the appeal against acquittal under prevention of corruption. The respondent was acquitted, I preferred an appeal, section 5 already allowed. Special leave to appeal is pending, lordship. The respondent intends to file affidavit in opposition.
Let him file.
Lordship.
Time for filing affidavit in opposition is extended.
Item number 7.
Ma'am, I appearing,
19 of 2024.
in this case, I'm appearing for the petitioner, my lord. As he is not in station, my lord, I'm paying for 2 days time, my lord. It may be fixed on Tuesday, my lord.
A straight
Obliged.
list on.
Item number 8, WPCT 34 of 2024.
I am appearing on behalf of appellant, my lord. On behalf of case Sabir, my lord. My lord, there is a waiting for AO, my lord, in this matter.
My lord, in this matter today, I am filing my Wakalatnama on behalf of the private respondent. I seek time to file opposition.
This is an appeal.
It's rising out of an order passed by the Central Administrative Tribunal, my lord. In tribunal also, my lord, I don't know for what reason, my client was not represented there. Though the order is passed in his favor, but he was not represented. I want to bring all the documents so that.
The order is passed in his favor and he was not a party.
He was a party member, but he didn't appear, or he said that no service was affected upon you. I don't know. This is what he has instructed, but it seems that he didn't appear before the trial. Because he was the beneficiary of the appointment by the administration. So administration succeeds, so he succeeds.
Oh,
The other party is challenging his appointment, saying that he was not entitled to the benefit of.
so you have defended your action
He have defended that.
and he is the beneficiary of the
Yes,
action.
yes, sir.
The Mr. So and so submits that a Wakalatnama is being filed in course of the day on behalf of
Respond number 6.
respondent number 6. Stop. He seeks some time for filing an affidavit in opposition. 2 weeks' time is allowed. List in the next available cycle.
MAT 41 of 2024 with 10 and 10.
My lord, this is that matter where, my lord, that 17B issue has arisen. My lord may have the impugned order first. मेरा लिखा हुआ था पैरा नंबर, हाँ रखा है। Impugned order, my lord, is part of the memo of appeal.
Page?
It begins after page 5, my lord.
Oh, it must be a certified copy.
Yes.
No, the only issue, if we remember correctly
Yes,
from the last day, is that post facto whether
Yes, my lord.
it
And my
can
lord-
still be enforced or not.
Yes,
That is the issue because it has lapsed.
Yes, and my lord, the order, the final order. had
You
to-
were obligated to pay the amount.
Yes, well, that is the question. The final order, my lord, I had handed over on the last occasion. However, file me over. This should be there, my lord. Judgment of the Honorable Justice or Arijit Banerjee, my lord.
Yes.
So this is the final order. And my lord will find that the final direction, paragraph 29. In view of the aforesaid, I set aside the impugned award and remand the matter to the Labour Court for considering the matter afresh in light of observations made in this judgment and pass a fresh award in accordance with law. I clarify that even if tribunal comes to a factual finding on the basis of material on records that the concerned DRMs in fact worked continuously for 240 days in a year and the provisions pertaining to retrenchment embodied in the ID Act would apply, the tribunal should consider whether or not reinstatement of the said DRMs should be ordered in light of the period of service rendered by them and the principles of law laid down by the Honorable Supreme Court in the decisions discussed in the judgment ID Act. Since the matter has been pending for 4 years, I request the tribunal to give some precedence to this matter and arrive at a fresh decision if necessary by calling for further evidence. So, my lord, in terms of the order, the matter is now pending, my lord, before the Labour Court. It is of course a different matter that they have.
So what is the ground for interfering with the order?
No, yes, my lord. Now, the ground for interference is, according to the learned single judge, there was the evidence on record to dispute this finding of 240 days was not considered. The learned single judge also said that they made certain admissions, etc.
So apart from 25F of the ID Act,
Yes, sir.
there are certain schemes of the railway also, which say if they have worked for 240 days in a year.
My lord.
That has not been considered. That
No,
was
railway is not involved here, my lord. This is
Oh.
they are DRM working for the administration.
administration. So there is no such
No,
decision by the administration.
no, my lord.
It is purely under 120
Purely under the
25F.
25F, my lord. So, my lord, firstly, there are two aspects. One is whether they work 240 days. The other aspect is, my lord, whether they are entitled to reinstatement. Because, my lord, merely because 25F is attracted does not automatically mean that in every case reinstatement will be granted. They may be given monetary compensation also. And the provisions of, my lord, 17B, my lord, if my lord has 17B of the Industrial Disputes Act, this, my lord, says payment of full wages to workmen pending proceedings in higher courts, where in any case a Labour Court, tribunal or national tribunal by its award directs reinstatement of any workman and the employer prefers any proceedings against such award in a High Court or Supreme Court, employer shall be liable to pay such workmen during the pendency of the proceedings. So, my lord, the prerequisite, my lord, for the benefit of section 17B is an award of reinstatement. So, my lord, the learned single judge has set aside the award of reinstatement and has in fact asked the
No, the
Labour.
prerequisite is not a reinstatement. Prerequisite is a reinstatement and pendency of an appellate
Yes,
proceedings.
yes, absolutely.
Both combined,
Absolutely.
not in isolation.
Yes, yes, absolutely. So, my
So when, as long as both existed, can the employer be allowed to shy away from such obligation or not? That is the issue.
yes, my lord, that is
Admitted
absolutely.
position is, which is not in dispute, whether the appeal was to your, the order was to your liking, correct, bad, indifferent. There was a direction for reinstatement. And there was a pending appeal before the High Court.
Yes, my lord.
These are the two prerequisites under
Yes.
17B.
Yes, my lord, absolutely.
So this being the background, why you should not pay, that is the only issue.
Yes, my lord. But my lord, my first submission is, my lord, judgment. My lord, I am relying upon a Supreme Court judgment, my lord. Oh, एक ही copy दिया है. Yes.
No, before you hand over the judgment, why you should not pay when both these conditions exist?
No, they do not exist, my lord. On date, they do not exist.
So therefore, that is the only, your submission is only that now it is not a,
That is right, lord.
so then, I don't know, this, what we have to see is when a statute casts an obligation, by flux of time, it will become unenforceable.
Yes, my lord. That is our submission.
Let us see, where has the judgment said that by effects of time, the obligation under 17B will become unenforceable
Oh, my
if
lord.
the situation changes. That's the only thing.
Yes, my lord, that is the only thing.
There was a direction for reinstatement. There was a pending appeal. The appeal was pending for more than 2 years. Now, the statute casts an obligation under the circumstance to pay the last paid drawn. No increments, nothing else, only the last paid drawn. It fixes at that and you have to keep paying as long as it is pending. Now, the fact that the appeal has been decided, you will find judgments galore that even if the appeal you succeed, you cannot recover the amount
That is
paid.
right, my lord. I cannot
So
have,
therefore, the statute says
a
to
legal
pay and
position.
forget about it.
That's right, but had you paid? Now the.
So therefore, if
situation
you
was
have,
haven't
if you,
paid.
if you have refused to acknowledge a statutory obligation, can you be permitted to derive benefit of such
My lord,
situation or not? That is what has
yes,
to
my
be.
lord, I definitely, my lord, in equity, my lord, of the stand which I am taking may not be fair, my lord, absolutely. I completely bow down to that. But my lord, what is the effect of the, today it's an
No,
interim order.
equity begins where the law ends. We are talking about the statute. The statute casts an obligation which you do not comply. Now, because of your non-compliance with a statutory obligation, there is a flux of time. Situation undergoes a change. So can you benefit from such non-compliance with a statutory provision, or the court is
I have
required to
tried-
ensure that the statutory provision is
At
complied
least
with?
one instance, my lord, one High Court, this division bench judgment, my lord, was a situation where the 17B application was kept pending. And then eventually when my lord, the High Court decided the challenge, High Court decided both and said that because reinstatement is being set aside, so 17B benefit won't follow. So my lord, today if a logical parallel may be drawn that eventually when the High Court says that, because High Court did not enforce the 17B, maybe that there was an order, but it was not subsequently enforced. So eventually when the reinstatement is set aside, the situation has to be contemplated on that date.
Minor nuances in the facts of every case may make a sea change in the application. There you said it was never decided. Here it was decided. There was a
That's right.
direction to pay.
Absolutely.
So that will not cover this case.
Absolutely. The second part is, my lord, interim order, my lord, interim order becomes not unenforceable once the final order comes in.
No, under this statute, it does not. That interim order is for its own sake applicable till the end of the proceedings and is not to merge in the final order. If that had been the situation, there would have been a provision for reparation, which is not there.
But if your lordships read it that way, my lord, then I do not have a.
But that's if you will find judgments which
My lord, that
say so.
reparation part, my lord, I have definitely come across, my lord, that had we paid, we wouldn't be
You
entitled.
couldn't be in a position to recover.
That is right, my lord. No,
Therefore, it is not a question.
what happens, I personally
Yes,
couldn't find,
yes.
my lord, any
We
judgment
have
which.
to view this provision keeping in view the social security object underlying the provisions contained in the act. It is a purely beneficial piece of legislation embracing the concept of social security for the workforce in the industry. And in that context, because normally it is the amount involved is hardly 8, 10,000, 6,000, something like that. And the employers are, it's not a level playing field, so to say, as regards the capacity of the parties. The statute is
So
such.
then, my lord, it should be limited to that duration.
It has to be, it cannot be beyond that. He cannot claim. The statute is clear as daylight. You just read it, what it says.
My lord.
Says during the period of pendency.
Tendency, that's all. It further says the last pay draw means what he was drawing on the day he was removed. There may be a lapse of 10 years. He will not get any increment. He will not get any other benefit. It will be locked at the rate at which he was getting on the
Right.
date of his removal. What judgment are you relying upon? Let us see.
My lord, this first is, my lord, Supreme Court judgment, my lord. This is generally on the effect of interim orders.
That will not apply.
Paragraph 15.
This is not an interim order. This is an order under 17B. It is to apply during pendency of appeal. It is not an interim order.
My lord.
So therefore, it cannot be covered by. And you are what is, you are an entity, you are the state administrator.
Public Works Department.
You are raising an issue involving hardly anything.
Not may pass the order, my lord. I can only assist the court, my lord, assist my.
Yeah,
The order, impugned order has been passed. Why you arguing?
but from the date of implementation.
Whatever the impugned order has been passed.
उससे पहले काम हो जाएगा वो।
जो भी impugned order में है, you have to follow the provisions. छोड़ो नहीं छोड़ो. And my lord, the second judgment, my lord, which I was mentioning, is by the division bench, my lord, where paragraph 49. Here, my lord will find that the division bench was paragraph 49 in the second last page. The question which now remains is whether the learned trial judge erred in allowing the application filed by the workmen under section 17B of the Industrial Disputes Act. Then 17B set out. A plain reading of the said provision clearly shows that unless an award of reinstatement is of course not applicable on the facts, but I was relying on this only to say that if the order of reinstatement goes, then the order of 17B also goes. So my lord, here my lord, both.
Where is that?
Kindly see page
Paragraph?
paragraph 49 onwards. A plain reading, kindly see paragraph 50. A plain reading of the said provision clearly shows that unless an award of reinstatement has been passed, the said provision will have no application. The award on reinstatement cannot be an award on absorption. Then, my lord, the court
So
says.
there was no order of reinstatement in that case?
Yes. No, that is right. There was no order of reinstatement at all. But what I'm trying to say is if there is no order of reinstatement here because of the order of the learned single judge, then whether a parallel can be drawn that because the order of reinstatement is not in existence anymore. So my lord is hearing for an appeal arising out of. So because my lord is also here, that appeal has also been filed by the workmen. Now, my lord, if your lordships were hearing both the matters together, then your lordships would be hearing appeal against the final order of the learned single judge and appeal against this order under 17B. So, my lord, in a similar situation, the court has said that reinstatement was erroneous. So, therefore, 17B also goes. So, similarly, in this case, if your lordships were to uphold the order of the learned single judge and agree that reinstatement was erroneously granted, then your lordships could also, in a similar situation, say that 17B order also couldn't have been passed.
No, this case there was no order.
No, here this is slightly different because here they said that this is an order on absorption.
Slightly different. It is
The statutory obligation doesn't come in. I appreciate, my lord. Here the statutory obligation didn't come in.
Didn't come into existence.
Didn't come into existence because it's a prima facie. Lastly, my lord, the order passed by the learned single judge in the which is challenged here.
Yes, a payment of such dues post facto or after disposal of the appeal. Got any precedent on this point? There may be hundreds of cases like this.
काम बट नहीं करना उसी से भी कर सकते लिटिगेशन में
तो वही तो डायरेक्शन तो वही है तो डायरेक्शन पढ़ो ये वाला
Anything else?
So, well, I couldn't find any judgment in a similar situation where after the final order of reinstatement has been set aside, this 17B, because my lord, I could have, if I was a private party, I could have simply withdrawn the. What would happen in that situation? Had I withdrawn, unless your lordships were to then take a step further and say that we will not allow you to withdraw without complying with this. I'm just trying to contemplate a situation. As a state, we can't just withdraw proceedings like that as per the. So, my lord, had we withdrawn the appeal, how?
If you withdrew the appeal, then you would have to reinstate him.
No, withdraw this appeal against the 7. Today, I could have come and submitted that, my lord, the final order has been passed in my favor. So I want to withdraw this order withdraw this appeal against the 17B order. And if your lordships permitted me to withdraw, how would the workmen enforce the 17B order? Because today that order is not in existence, my lord. It doesn't exist. I understand it's a separate statutory obligation. But my lord, eventually if the proceedings themselves are disposed of, then my lord, the proceedings don't exist. In that he can apply again. In fact, he can't apply before the labor court for this order. He had to apply in the appellate proceeding which has been disposed of in my favor. So if I were to withdraw this appeal, he would have nowhere to execute the order.
Only issue which arises for consideration is whether the subsequent event of disposal of the proceeding before the High Court will nullify the effect of 17B.
My lord, with the greatest of respect, my lord, it's not merely a question, or not only a question of disposal. It is also a fact that there is no order of reinstatement which is in appeal. Because my lord, the prerequisite of 17B has had fallen from your lordships,
But
is that there has to be.
There is no application pending under 17B today. Therefore, this submission may not be of any relevance. If he were making an application for 17B, then you could have said there is no order of reinstatement. The order of reinstatement was very much in existence when he made the application. The appeal pendency was very much in existence when he made the application. The statutory obligation you also cannot dispute or deny was very much in existence. Therefore, this subsequent event of the proceeding being disposed of, can it make redundant the beneficial intention of 17B?
This beneficial provision has been provided for presupposing that there is an order of reinstatement, presupposing that yes, the workman has an order in his favor. Now, my lord,
No. The workman has an order in his favor and the appeal is pending.
Yes. So now once that order goes,
No,
the situation changes because he is no more in the right, he is in the wrong. Because once the order of reinstatement is not
it is
fixed.
not dependent on his being right or wrong.
But why not the section
The
says?
statute says it must be paid, and the statute says it cannot be recovered even if he was wrong. That is the legislature's intent.
But once the money is given, it cannot be recovered. But if
Yes.
the money is not given at all, can he
So
seek
therefore,
that money? That is the
therefore,
question.
your non-compliance with the statutory provision will inure to your benefit.
But I was in appeal. I had challenged the order in these proceedings. The court, in its wisdom, did not enforce the order pending the appeal. They also did not move. They moved a contempt which they withdrew. So, my lord, they also chose not to execute the order. They did not see. They could have moved an application before the
withdrew a
division.
contempt.
They
withdrew a
did
contempt.
not file the contempt. They did not file the contempt. I apologize. There was some confusion. No, I think the contempt was filed initially. Be that as it may, my lord, they did not move. They could have moved in very well, my lord. They could have moved an application before your lordships. Your lordships were hearing the appeal against the learned single judge's order directing 17B was challenged by me in appeal before your lordships. So it was open to them to move an application saying that, or they could have moved contempt, saying that why are we not complying with it. So by their own actions, my lord, they are also estopped in that sense. From today contending that this benefit should be given to them. Honorable High Court could have directed us to comply, my lord. High Court was aware that this order is in existence. Unless my sympathies are completely with the workmen, but my lord.
No, the court is not being guided by any sympathies. It is the intention of the legislature very well drafted in the procedure, in the provision containing the grant of such a social security benefit to the workmen under the Industrial Disputes Act. That has to be given effect to.
But had it been
whether there is sympathy or no sympathy, that comes later.
No, but my lord, we have preferred this appeal. Typically state the order passed by the learned single. The situation would be different. But there was no specific stay, but at the same time, the order was not enforced or executed. This will then become a precedent, my lord. May say that it is your lordships are exercising jurisdiction in equity and granting this treatment. Oh, that is if your lordships are not at all in agreement with me, then I don't have any submission on that one.
So, my lord, that
Party claim an equity by virtue of what he has defaulted in doing.
if I were to turn it, to put it differently, my lord, he may have a right, but he does not have a remedy anymore, my lord, because the final order has been, the order of reinstatement is set aside. So he may have had a right during that.
So you have defeated his remedy by not complying with the statutory liability.
He has defeated it himself by not executing or enforcing that
So
order.
what was he required to do to execute?
He could have filed a contempt. Mere pendency of appeal doesn't mean there cannot be contempt. He could have moved an application before this honorable court, my lord, which was hearing this appeal. This appeal was also adjourned from time to time. And eventually the learned single judge decided in my favor. So during this entire 1 year period, it was open to the workman also to seek to knock the doors of the court. He decided not to. He awaited the decision on in the writ petition, which happened to be in my
Honorable
favor.
single judge's order is dated.
My lord, which is challenged in these proceedings. That
1st of December 2023.
21st of December 2023, and the order of the learned single judge in the finally disposing of the proceedings is 12th of November 2024. And this appeal, my lord, was preferred
Of July 2020.
26th of July 2024. So there was a period when the appeal was also not filed.
And when was the writ petition filed?
Writ petition was filed on 18th of March 2020.
And in fact, there was a huge delay in even filing the 17B application. 2020, the writ was filed, and the 17B application much later, where 17B was filed sometime in 2020
Now,
to 17B application.
just go through the provision to show that making of an application is a prerequisite to grant a benefit under 17B.
17B the call. Industrial Disputes Act. This says, my lord, where in any case a labor code says employer shall be liable. But it says employer shall be liable during the period of pendency of such proceedings.
Correct. Therefore, we have been observing since the very outset, it's a statutory liability. It's not dependent on making of any application.
But does this, the question is whether this obligation will survive.
Correct. Whether
even
it
after
can
the
be
proceedings.
extinguished.
Whether
If
it can be extinguished.
by non-compliance of the party who is obligated to comply with the statute, whether it can be extinguished by.
My lord will also, my lord, consider that this is, of course, this is academic submission, but my lord will consider that technically, my lord, since 2020, it is not as if actually anybody is unemployed, my lord, in today's day and age. To say that, my lord, this.
If you had raised that dispute, it would have been different. You had the option.
Oh, of course, they filed an affidavit.
They had filed an affidavit as per 17B. That issue does not
And in
arise.
terms of the order also, we filed affidavit before the
We
authority.
have seen that. That's why we had adjourned it to go through the file. We have gone through the facts. We have also read the provision. Therefore, we are saying that there is no making of application is not required. It is a statutory liability arising under the provision.
And my simple submission is, my lord, that now the order has been set aside. So there is, today I'm in appeal.
That we have understood.
So if I have not complied with an order, the recourse is contempt or execution. So today would they have been able to execute the order, or would they have been able to move a contempt in respect of the order passed under section 17B? When finally the writ petition is not in existence, it has been disposed of.
The Act does not contemplate any remedy for non-compliance with the statutory requirement under 17B.
My lord, since the order under section 17B is passed by the higher court, that is High Court or Supreme Court, I can always file a contempt application before the High Court.
Because as in these proceedings, what is in issue is the validity of the order.
My lord.
But he is saying that now it has become infructuous.
It is not like that, my lord. Already there exists an order in my favor under section 17B. They have challenged it before this court. Suppose today this court reject their application, then I can file contempt before this honorable court if this court consider everything and thereafter pass an order, thereafter gives some time to them, then I can file appeal before this contempt.
So on what ground are you assailing the order? Let us come to it. You have filed an appeal assailing the order from the
Today, no, my submission today is, my lord, that this appeal was against again, I appreciate it's a statutory obligation. But this appeal is against an interim order passed in by the Honorable High Court while hearing the writ petition.
So what is wrong with the order? You make
But my
it.
lord, the interim order doesn't exist anymore, my lord. The final order has come into force. So, my lord, the interim order is non-est now, it doesn't exist. In the usual course, my lord.
Therefore, we are asking you, what do you want?
My lord, what I'm only submitting that this, according to me, my lord, it has become infructuous now because
Then what has to be disposed of as infrastructure?
because final order has been passed. If he has some remedies, he'll take it under the.
He will do it. He will do whatever it is.
Yes, my lord, then
yes.
open, my defenses will be available then. one last submission I wanted to make, my lord. My lord, so if one reads 17B, my lord, this is a right, my lord. It is in effect a right which is in existence during the pendency of the proceedings. Because, my lord, this is a workman who has been awarded reinstatement, which is a very valuable right, therefore, to be reinstated in service. Now the workman that has been challenged by the employer. So while that right is in existence, this is a beneficial kind of provision. So therefore, even if the employer succeeds eventually, this money is not taken back. But the fact of the matter is, this is not a vested right. It is only a right which is in existence during the pendency of the challenge before the High Court or the Supreme Court. So my lord, if that right was for whatever reason could not be availed of by the workman, and then the order is set aside.
Right by the person obligated to comply. Every right has a corresponding duty and obligation. The corresponding duty obligation lies on you as per the statutory provision. So if you refuse to acknowledge that corresponding right and obligation, his right under the statute gets extinguished by flux of time. That is the effect of your submission. However you may put it, that is the effect of your submission.
Slightly differently. It was open to him to enforce that right or during that period if he hadn't done so.
So therefore, you being a state, apart from being an employer, you being a state can refuse to comply with a statutory obligation which is due, which is also reiterated by the court, and then come around and say that now we will not give in.
That
This is a unique circumstance, sir. You are a state. What is bothering us is the state is making such submissions. You said sympathy, we are so told you it's not a question of sympathy. You are a state. If you are a company, then of course these submissions we would have.
No, I appreciate.
What is this? So we said.
No, that I'm not.
This is a state, we'll have to record this, that this is a submission coming from the state.
Why not by pass? Why not by do that? Why not by pass the order?
No, but these are the submissions. See, you are a council, we appreciate. You need not say that. It's not that I have come here directly jump from somewhere. Yes, what is your submission? His whole, see, his case, he has put it in a very narrow compass. He says whatever, it was a right in existence during pendency of the proceedings. Now it is, we still don't know what he is expecting from the court. If you say it is infructuous, you want to withdraw. It's a.
Withdraw, my lord. I can say it is infructuous, why not? Then you're not.
What does that mean? If it means infructuous, then it will be not pressed.
I
A
can't.
matter cannot be infructuous and still a court has to pronounce a judgment on that.
Appreciate it.
It cannot be both ways.
No,
Once you say it is infructuous, it goes.
I-
Yes.
My lord, my submission is very limited because everything has been fallen from my lords. Now, the only thing is, my lord, section 17B has been inserted in the legislature in 1984, and it is a beneficiary legislature has fallen from my lord. My lord will find that the language which is there in section 70B says direct reinstatement of any workman and the employer prefer any proceeding against such award, and in the High Court or Supreme, the employer shall be liable to pay such workman. So, my lord,
You are not addressing the issue. We are asking you, how are you to enforce this?
my lord, the writ court has passed an order. Now, my lord, the moment this appeal is, suppose, my lord, this tomorrow the appeal is dismissed, I will see if time frame is given by this court, then I have to file a contempt before this court. If it is simply simple dismissal, I have to approach the writ court for executing the order. That is for filing contempt against them. This is the only recourse. Because, my lord, if that could be an order under the Industrial Dispute Act, then I have to take recourse under section 11 subclause 9 of the Industrial Dispute Act.
What is that? 11.
That says, my lord, if any order is passed by the labor court, the award is passed. If it is not executed, then in that case, I can take recourse under order 21 before. That is altogether different. Here, this remedy is available before the High Court or the Supreme Court. That's 17B. So once the order is not complied, I will take the recourse of filing contempt.
If a benefit accrues in favor of a workman, which is to be computed in terms of money,
My lord.
which provision will apply?
My lord, yes, my lord.
Are you doubting the accrual of benefit in your favor? That you are not doubting.
No,
Only the money has to be computed.
money has to be
The
computed.
claim has to be computed with effect from the date gestation period of the appeal
Yes,
and the payment made.
Yes.
So which is the appropriate provision?
my lord.
11.9 will not be.
No, 11.9 not, I said,
Therefore, we are asking.
my lord, I am saying that since it's an order passed in a writ proceeding by a writ court, I have to file a contempt application for non-complying with the order of the court. If under section 33, any order is passed with regard to some payment and in industrial dispute, then I have to take recourse. That is altogether different. But my lord, that
And what is 33C2?
33C2, my lord, if my lord sees, recovery of money, my lord, under the statute, my lord, I am saying,
Oh, please read, sir. Please read
Yes.
33C2. We read the statute hundreds of times. It is revealing something every time you read.
where it says where any money is due to a workman from an employer under a settlement
Yes.
or an award or under the provisions of chapter 5,
So we said 33C2.
my lord,
33C2.
where any workman is entitled to receive from the employer any money or any benefit
Any money or any benefit.
which
Yes.
is capable of being computed in terms of money, and if any question arises as to the amount of money due, as to the amount at which such benefit should be computed, then the question may subject to any rule that may be made under this act to decide by such labor court as may be specified in this behalf by the appropriate government. My lord, this, to my understanding, my lord, this is within the ambit of the Industrial Dispute Act.
This liability arises under 17B, irrespective of passing of an order by the High Court. It is only affirmation of a statutory right or recognition of a statutory right arising under 17B, for which no application is required.
My lord,
So it is, whether it is any benefit which can be computable in terms of money under 33C2 or not.
my lord, may I say this, my lord? Since the order is being passed by a writ court, though under the provision of section 17B, this court, the writ court, did not lack jurisdiction to entertain a contempt application. There is no statutory bar, my lord. My lord, that may be left kept open, my lord. Yes, my lord. That because that is not even my learned friend's appeal is confined to that order of the 17B. So that recourse, my lord, as per law, whatever permissible, I will take.
The learned counsel for the appellant submits. One more. Welcome.
Item number 10, 27 of 2024.
These two intra-court appeals are amongst the bunch of matters because other matters have been dismissed. Lord, they may say that on the ground of parity of reasoning, the same order needs to, but I would.
Lord, I'm just
Something
handing
what
over
Lord
the order
says.
past.
I'm saying that only.
Allow him to complete, he'll hear,
I'm
don't
saying
worry,
that.
yes.
Not considering it. So I would say, my lordship, Lord would see the last order passed in the present proceeding. Certain factual findings recorded by the court while dismissing those appeals are under contemplation in an appropriate proceeding. So I would pray these two matters be taken up in the next circuit. Or if the Lord allows me, I can place this facts because the facts which were recorded by these coordinate bench in those appeals, identical appeals, has not been properly addressed.
All 7 cases or 5 similar cases. 5 already.
What is the issue? Can we know, please?
My lord, just I'll say, let me take it. My lord, what has happened? My predecessor was an encroacher of a particular piece of land in the north and middle district. Time to time, administration was introducing schemes. The first scheme is of 66. There is no rider embodied under that scheme. If any encroacher is found occupying the land, any extent, the administration regularized the land. Then that 66 scheme was superseded by 87 scheme. In the 87 scheme, certain preconditions have been provided. One of the primary precondition is not that one who found occupying a government revenue land prior to a cutoff date of 31/12/1978 is entitled to get the benefit. 87 scheme. Then a later scheme of 2003 came into force. That's on 15th July 2003 scheme. But that scheme is confined to Port Blair municipal limit and it is confined to pre-1942 categories. These are the 3 schemes. So far as my clients is concerned, Lord, his case falls within 87 scheme. The administration was approached with a request to regularize it. At the first instance, nothing was done, a writ was taken out. Simplicity, a direction was given to the authority to take a decision in one or other. The decision gone against me. I filed a writ. Single judge dismissed the writ petition. An intra-court appeal was taken. Petition against which this appeal has been filed. So my point is, in the first round of appeal, intra-court appeal, the directives given to the writ court was not adhered to while passing the impugned order which have challenged in the present appeal. And this issue was in fact not gone into by a coordinate bench while deciding the rest of the appeals, because there are 7 appeals. These are the 2 left out appeals. Those 5 appeals, fact findings have been recorded not properly. I'm contemplating to take out the proper application. This has been recorded during the last circuit also. I'm within time. Or if I can not a slightest.
If you are filing a review, why the appeal should be pending?
No, I would go for a modification of review order 47, not the scope. Scope of order 47, rule 1 CPC.
But the order records that the application for review will be filed.
Nomenclature, so I have to go for a modification. As regards if review, I cannot. Order 47 scope is very limited, my lord knows.
It's not a question of order 47. You are saying that the order of the division bench has not been complied with.
My lord.
So it would be essentially a review under Article 226.
So, what I propose, subject to what my lord says, if these 2 appeals are
1963 Supreme Court 1909.
My lord.
The judgment of Shivdev Singh.
My lord.
I hope I've got that date right. 1963 Supreme Court 1909. Anybody has a system here? 1963 Supreme Court 1909. Case of Shivdev Singh, judgment of Shivdev Singh. A review under Article 2.
Demonstrate because these 2 appeals, because the parity of reasoning cannot be made applicable so far as these 2 appeals are concerned. Because facts is something else. Recording.
Please show us just one thing.
My lord.
The first application which was not being decided, which was later on decided subsequent to an order passed by the writ court. Where is that first application?
For that, the writ petition needs to be placed. It's a memo only. It contains the impugned order. The entire writ petition, if Lord allows me, I can bring it on record.
So that application was considered by the division bench or single bench?
No, it was at the first instance was not considered by the authority, writ taken out, dismissed.
No, because you are saying that your claim is under the 87 scheme.
Absolutely not.
They are saying pre-42 scheme.
My lord,
This is the only.
my lord, my lord.
Those batch of cases are in relation to a pre-42 settlement.
No.
Same.
All are sailing in the same boat. All are sailing in the same boat. But my lord, no, the fact recorded, that's what I'm on, Lord. In the first round of
Case
Same case.
that their predecessor Surin Mandal was an encroacher, and this case was of 1977. So
And all of them are claiming through the same Sorin Mandal.
Yes, my lord.
Then there has to be parity.
No, they cannot, Lord, if
There
Lord,
cannot be disparity.
no, it can't, the parity of reasoning, Lord, that can't be made applicable insofar as these two left out appeals are concerned. Lord allows it.
If there is any distinction from this judgment which has been
Lord,
passed,
Lord,
we are willing to.
Lord, I can place him, Lord knows even a slightest recording of
Let
fact
us see, let
makes an authority value.
let us see. It's
Lord,
not an authority, it is the same claim by the same set of people claiming through the same person under the same scheme. There is no distinction. There is no distinction.
The fact
In
recorded.
fact, deciding otherwise now would not only be opposed to judicial discipline, it would give rise to a different judgments arising out of the same facts and
Judicial
circumstances.
nicety demands, my lord, knows in the first round of intra-court appeal, my lord, by this court.
Let's see, we'll go through the facts.
May I bother not to this single judge order norms?
Yes.
Lord, it's a judgment dated 5th of August 2024.
We'll take it up tomorrow.
Lord, may I give maybe given liberty to place the writ petition on record? I will just, if such liberty is
You
accorded.
can give a copy to all of us. Tomorrow we'll get. The Learned State Council submits that should
Any mentioning not in the will?
This matter, for the petition. Yes. Everything has been exchanged, but it is not in the list for hearing, it is ready for hearing. No, including the list. Fine, okay.
My lord, one matter, herein, even after the election passed by this honorable court, the respondent has not filed their opposition. 4 weeks time has been given, it's been 2 months already, and it's not there in the list as well.
Monday.
Published.
In the list. Item number one, WPA 5/2025.
My lord, I appear on behalf of the respondents, all the official respondents, my lordship. One private respondent is also.
But there is a private respondent also. It is submitted by the learned counsel for the writ petitioner. That service upon respond number 3. Service report in respect of service upon respond number 3 is still awaited. Stop. He seeks the matter to be taken up after 1 week. To be taken up on till the date of Monday. Stop. List accordingly.
Item number two, WPA 320/2024.
I am appearing for Central Provident Fund Commissioner respondent.
You have to file a reply. Opposition has been filed.
Already filed. Long back.
For filing a reply, and counsel for the petitioner seeks an adjournment till give the date of Monday. Stop. List accordingly.
Much obliged, my lord.
Three, WPA 486/2024.
I appear on behalf of the respondents.
It's pending in the Supreme Court. What is pending in the Supreme?
Lord, I filed my opposition, my lord, on affidavit and
It's pending in the Supreme Court.
yesterday also.
What is the case number?
This number. I've mentioned in my opposition. my lord.
Yes, which paragraph?
10, 11. Like, page 5, my lord. The Honorable Supreme Court and
Civil appeal number is there.
IA number 1659 of 2006.
In which civil appeal? There must be SLP or civil appeal number, something like that. WPC 202.
Yes.
Oh, it is pending in the Godavarman Tirumalpad matter. It is pending, IA is pending in that matter.
Yes.
So then it has to come after disposal of the IA.
Meantime, I should not be disturbed.
That you can pray for before the apex court. The parties, yes.
I am person for the last 40 years.
We don't know. The matter is pending before the apex court. Either
License.
That is not from
may have been,
the list which is.
may have
submitted to
been,
the Supreme
may have been.
Then, my lord, I am praying to let it be decided on.
Yes, let's proceed.
Yes. One day time will be given, I will file, after they fight. By Monday, I will file my.
Reply. For filing reply, the learned counsel for the appellant seeks
Item number 4, here 56 of 2024.
Lordship, I have for the praying. Item number 4 and 5, Lordship, I am praying for 2 days time, Lordship, the matter fixed on Monday.
As prayed. List on give the date of
I am
Thursday.
preparing for respondent, my lord, appeal will lie, my lord, yesterday I raised this meeting.
We asked him to go through
I will satisfy the honorable court regarding the state on Monday.
on Monday. Keep it
Okay.
on Monday. As prayed,
Okay.
list on. Both. Ah. Send it on Friday. Because it's on Monday. you say.
Item number 6.
Lordship,
Lordship,
as per direction of this honorable court, I have brought the supply regulation, Lord. Chapter 5 is speaks about the granting connection and everything.
Where is the procedure for application?
Chapter 5, Lord.
Chapter 5, which provision for application?
5.1.
It's 5.24. So 5.307 and 8 covers it.
Yes.
They are not required to have any proof.
Lordship, settle position, we have to take in,
You
consent from
read
the
your 7, this is your supply code, you read your 7. A separate indemnity bond, if they are not able to establish that they have been permitted by any
Yes.
owner, then they will give an indemnity bond. 8 says, in case of JG cluster or other area with no specific municipal address, you may accept either ration card or electoral identity card having the same address as proof of occupancy only for the purpose of release of electricity connection
Yes, Lord.
or no other person. So if they comply with this, you have
Let
to,
them comply 5.30, Lordship. We are ready to provide the electricity connection.
you are appearing.
Yes, I am appealing, Your Lordship.
What have you annexed? You have annexed
As the Lordship have stated, Your Lordship, indemnity bond declaration, undertaking, entire thing has been submitted, Your Lordship. And the format,
no, indemnity bond can apply in 5.307.
as per the requirement, Your Lordship, they have asked for a declaration and under affidavit and undertaking, Your Lordship. The
Who
three
has asked for?
the department concerned, Your Lordship.
And you have given that?
Yes, Your Lordship. And online, that will be submitted online, Your Lordship. Your Lordship sees page number 8 is the online application. Along with that, Your Lordship, entire detail was submitted before the.
Where have they asked you to submit the indemnity? You said they have asked you to submit the indemnity. Where? Where is the?
This is the format they are asking verbally, Your Lordship, to submit here. In every cases of the electricity case, Your Lordship sees the in undertaking also. The format has been given by the department concerned itself, Your Lordship. If Your Lordship comes to page 10, Your Lordship. This is a format which has been given by the department concerned. Page 10 of the writ petition, Lordship, the declaration of undertaking, Your Lordship. The entire format has been provided by the department concerned itself, Your Lordship. It's general, Your Lordship, and it has to be submitted before the department concerned. Nowadays, it has been submitted through online.
What is your proof of occupancy that we are asking you? It contemplates documents such as voter ID card or ration card.
Ration card. In this, Your Lordship, I have not annexed, but I have my Aadhaar card and election card.
You have it?
Yes, I have it.
So you will supply that?
Yes, sir.
Subject to their supplying, you consider
Yes,
their
sir.
application.
Yes, sir.
The petitioner is
Whether they have served or not, I do not know.
Yes, give the file. Yesterday it was called. Yesterday it was called. None appears for the petitioner. List on Monday give.
Item number 9, PA 2 of 5.
Here, Lordship, we have rejected the application of the petitioner on the ground that he has not submitted the ID proof properly. Yes.
The order is challenged.
Hmm.
Where is the order? Where is the order?
Page number 21. It was rejected on the ground that the ID proof applied to the department. The address mentioned in my Aadhaar card and address mentioned in my application is
So what is the effect? There is no ID proof in respect of the address.
Now I am residing at Calcutta, which is the adjacent village.
So there is no proof. There is no proof for the address. They are correct. That is not their obligation. You have to submit a proof of the address from which you want the supply. We don't know. That's why we have seen, you must have read the provision. There is a provision for taking a certificate. You comply with it. The petitioner's application for supply of electricity has been rejected on the ground that the identity proof submitted by him contains an address at variance with his present residence on an occupied land. To stop, the learned counsel for the petitioner submits that because he has shifted his residence to an occupied land in another village, a variance has occurred. So he submits that he would be approaching the authorities by application afresh, supplying the requisite information as contemplated under clause 5.3 of the Supply Code 2018 for availing the electricity supply connection for stop, with liberty to the petitioner to approach the authorities, comma, as prayed, stop, comma, the writ application is disposed of.
Item number 10, September 1 of 2024. Arises out of an award passed by the MSc. Question involved here is my lord, the applicant before the MSc tribunal was already given the benefit under the workers' compensation. Why not we were relying on section 160?
There is a provision which says
The MSc tribunal has rejected that objection and has said additional benefit can be.
which is that provision?
167.
Motor Vehicles Act, Motor Vehicles Act.
7 months. Hence that my lord. Option regarding claims for compensation in certain cases. Notwithstanding anything contained. notwithstanding anything contained in the Workmen's Compensation Act 1923, where death or bodily injury to any person gives rise to claim for compensation. This is a case of death. Under this act, and also under Workmen's Compensation Act, person entitled to compensation may, without prejudice to the provisions of chapter 10, claim compensation under either of those acts, but not under both. This section has not been at all noticed, and instead the learned tribunal has referred to section 164(1) and as the 164(1) says, payment of compensation in case of death or grievous hurt. It says notwithstanding anything contained in this act or in any other law for the timing and force of instrument having the force of law, owner of the motor vehicle or authorized insurer shall be liable to pay in case of death or grievous hurt due to any accident arising out of use of motor vehicle compensation. So my lord, this notwithstanding this non-obstante clause has been relied upon by ignoring 167, which is more specific. Respondent.
And what is chapter 10?
Chapter 10, my lord. Chapter 10, my lord, is the next chapter.
It says without prejudice to the provisions of chapter 10.
10, my lord. As deleted.
Deleted.
Liability without fault in certain circumstances. This was, my lord, omitted by the amendment of 2019, which came into force in 2022.
But the provision has not been amended. 167 has not been correspondingly amended.
Yes. And even, my lord, my understanding would be that chapter 10 would act as a restriction on that. Without any. In any event, but the tribunal has not proceeded on the basis of chapter 10. The other side had appeared, and my lord, there was a direction to deposit, so we have deposited the amount in the court. For the High Court itself.
You serve and come back.
Sir, hearing matter will go from that.
They are appearing.
Yes,
Ask him to be here then.
we try to get it first.
No, if you think he will appear, then otherwise we can direct you to serve afresh.
Serve a fresh one.
Right, let the notice be served afresh as there is none representing the respondent in today's proceedings. The matter be taken up on Thursday, the next circuit, in the next circuit.
My lord, I am. Is he responding to you? My lord, I am appearing for the respondent number 1 hearing BSL. The petitioner here in the petitioners are not taking steps from a couple of days, couple of occasions. So it will be dismissed.
None appears on behalf of the, it's an appeal
Yes.
on behalf of the writ petition. On behalf of the petitioner, stop. List on Monday. Let us see whether they come.
Yes, ma'am. Publish. Publish.
Number 12. Section 25 of 2024, where I am for the petitioner. Number 14, there was a tax on the respondents to file.
Not filed.
No, my lord, here, my lord, I am seeking, my lord, permission to, my lord, to be excused from this matter, my lord, because, my lord, this is a 340 application, which is against an individual, my lord. I am appearing for the government, my lord. I cannot take up a private.
Some authorities.
No, because after examining this issue, my lord, so, my lord, this Tehsildar.
But you will appear, he will also appear.
No, he is appearing for the petitioner. His allegation is that the Tehsildar made some false statements, and because of that, he has moved an application under 340. So, my lord, I appear.
The false statement was made in the proceedings here.
Not in the, no, I don't want to get into the merits. In some order which the Tehsildar has passed, he has recorded that hearing has been granted. So, in his order, he has said that notice was given. Now, my lord, this is a personal matter. The Tehsildar has to defend
Let
it.
us see which order. Yes, you please.
Well,
Which order?
Order number 18, page 18. This order was ultimately set aside by the honorable single bench.
order number, please.
The order of this.
Just allow us to read.
इसमें imagination नहीं है.
Hmm.
हम लोग रिसीव किया क्या? अप्रैल 2024 का.
And what is that page 26?
Ultimately, that order was set aside. Page 24, paragraph 3.
Yes, so what is, where is the occasion to initiate proceeding under 340?
That order was placed before this judicial proceedings. In contempt proceedings, he filed that comprehensive, taking that opportunity of hearing was given, but actually no opportunity of hearing was given. When record was called by the honorable court, from the record it reveals that no notice was served.
Yes, that has been recorded by the court.
Yes,
If at all a proceeding was to be drawn up, it was to be drawn up in those proceedings.
yes, my lord, because of this, that order, my entire structure was demolished. 30 years structure was demolished.
This proceeding under 340 could have been taken out only in WPA 326.
No, this affidavit was filed in contempt proceedings.
No, it was filed in WPA 326.
No, it was filed in contempt proceedings.
Which contempt proceeding?
It's at page 30, maybe see,
30.
13. Was part of the contempt obligation. Yes,
Please come to page 24. You read, due notice was served upon the petitioner before passing of the order by the Tehsildar on 10/4/24.
no, that was order was set aside. Honorable High Court set aside that order,
Correct.
10-4 order.
So it is in respect to that only that, or after that they are saying.
No. That I may be allowed to submit first. Actually, Mara, kindly come to.
Page 13 is which order? It is.
Page 10 may be seen first.
Your order.
Tahsildar passed on eviction order.
Correct.
Challenge that order.
Correct.
Kindly come to page 10.
Yes.
Operative portion at page 11.
Yes, he said parties have been heard.
No, this is SPO's order, subdivision officer.
All right.
Page 11. Hence, Tahsildar is directed to here be considering all the facts and giving the issuing prior notice to the appellant and respondent.
Yes, this is of 2nd August 2019.
Yes. It was kept pending.
Yes.
Thereafter, I approached this honorable court. Page
Yes.
12.
Yes.
Page 12 direction was given to dispose of.
Correct.
Tahsildar without giving any opportunity of hearing to me.
That all right. That is all right. That is now established fact that it was without notice.
Yes,
That is an established fact because the High Court has held so.
my lord.
So in that proceeding,
In contempt proceedings, the complaints was filed as part of the annexure.
so this order of Tehsildar of 24/6/24,
My lord.
it was
10/4, 10th of April 24, page number 18, was placed before the contempt application.
no, after the writ court's order, which order has been passed? After the writ court directed the Tehsildar to dispose of the matter, which order has been passed?
The 10/4 order.
Where is that?
That order is at page 18.
Page 18.
Yes,
So in this, he has recorded wrongly.
yes,
It is in this that you are submitting, he has recorded wrongly.
yes. In the contempt, I for this honorable. In honorable High Court, he filed on complaints. Stating that I complained that order.
In which contempt proceeding? What is the number of the case?
12. Page, sorry, page 30.
Yes, so this fact was known to you when the contempt matter was being considered. You knew that the order was wrong where it recorded that opportunity was given to you.
Was not given actually.
You knew this fact. You knew this fact that it is wrongly recorded.
Yes.
So if at all an application under 3340 was to be taken out, it was to be taken out in those proceedings. How it can be done in a different proceeding?
It's not in different proceedings. Contempt application only I filed.
The contempt is still pending.
No, it was disposed of.
So where is the order passed in the contempt proceeding regarding the 340 proceeding?
340 proceeding, nothing is there.
You are not filed, then how can there be anything?
13 may be seen. Or passed in contempt. No?
Yes. This is passed in CPAN 25 of 24.
Yes.
In CPAN 25, did you file an application under 340?
No.
Then that is where you are required to file. That is what I am trying to say.
In contempt application, he filed this complaints report.
Correct. And that is where you say that the wrong evidence was given.
Yes.
So it was to be filed in those proceedings. So why didn't you file 340 in the contempt proceeding?
Can application filed in contempt.
This is a can in the contempt proceeding is all right. So then
Passed by this court 14th November may be seen, first order.
first order. But the contempt is disposed of.
Contempt is disposed of.
Then where is the order disposing of the contempt?
It starts from page
Correct.
13, page 15.
So you filed the can after disposal of the can.
After this.
How can you? You cannot. You cannot. If at all you were required to do at the time of disposal.
Contempt application, he filed the false affidavit.
Yes.
Therefore, I filed in the contempt application.
You did not file any application.
No, it is filed in contempt.
After disposal, it cannot be. It was to be filed when it was still pending.
Still pending, I cannot file it.
Why not? 340 is to be filed in a pending proceeding. That's the basic thing. What do you mean cannot file it? Where 340 is to be filed in the pending proceeding. You cannot. You read 340. Whether it contemplates filing in a disposed of application, read 340. Please read 340. Please read 340. Please read 340. Read it. You come with it. We'll see after recess.
Fix tomorrow. Because of his fault, my lord, I lost everything. What is more important or the excessive is one. Inside.
So I pray your lordship, any advocate of this court can be appointed because no technicalities are there. It's a business related accounts and all these things. And I serve notice to the other side. I file affidavit service. Seventeen 2024 it was delivered. Yes, your lordship. Come before the arbitrator. They are not going. No, arbitrator has been appointed.
Paragraph 7.
7, your lordship. It is to say the suit being 2 of 2020 disposed of on 8/4/20 were directed parties to settle the issue before arbitrator. It is further to say, as per the direction of the Honorable District Judge, father of Shri Parimal Datta, my father, Parimal Datta, he is not party to the agreement. Invited and intimated you by letter dated such as such, wherein you are requested to come before the Panchayat Pradhan, Govind Nagar, Gram Panchayat, Swarajdeep, and further requested to fix the date so that issue can be settled, but you did not show any interest for settlement. Page 30. Fresh notice for service, intimating the date. Lordship.
Sought time, my lord, to file reply to our petition, my lord. Reply has not been. No, I don't. They have sought time to file reply to our affidavit of compliance.
Need to check.
We have not received.
Let it come tomorrow, Lordship.
नहीं फाइल किया. अरे PP करना.
Number 15.
Yeah.
WPA 52 of 2020.
Private respondent was
In
appearing.
view of the relief claim, no, the private respondent needs to, it's a writ of quo warranto. Her appointment has been questioned in this writ by way of a writ of quo warranto. Attempt has been made by from my end, Lordship.
I think last time someone appeared also. Rakesh Par.
Last time.
शायद appear किया जाए. नहीं.
Yes,
Huh?
5 and 6.
No, respondent number. It's respondent number 7. Her appointment has been questioned. The manner in which her appointment has been given
का role है हमारा नहीं था.
is contrary to law. Is contrary to law. As the in the post of just welfare officer woman. In transgression of the recruitment rules, her appointment has been given. So, my lord, this needs to be gone into. Unless her appearance is secure, otherwise, my lordship, she is the necessary party. I've arrayed as a respondent. So, 2020 matter, my lordship, because
Rakesh sir is appearing. उनसे बात कर लीजिए. बात कर लीजिए. Some advocate is, we were informed last time that some private advocate will appear. So if my learned senior can find out. Maybe if it is kept tomorrow or day after, next week. If it is kept next Monday, my lord.
I'll do one thing, Lordship, sir, notice once again. Because as of now, no wakalatnama has been filed.
Some lawyer, we were informed last time that some lawyer, private lawyer has been engaged. But my lord, he is not
Then,
here.
okay,
in
Lordship,
court
just
today. Let it
not
come
this
on
week.
Monday. Yes, my lord.
Not this week, on Monday. My lord.
Who? UPSC. One होगा, one होगा. Two होगा.
Item number 16. WPA 137 of 2020. Item 16.
Lordship, I am for the petitioner, Lordship. In this matter, Lordship, the petitioner and the respondent authorities are in talks, and there are every chances that this matter will get settled.
Your Lordship, Ms. Bhavita Das is appearing for respondent, Your Lordship.
The petitioner happens to be a fruit vendor, Lordship. He is aggravated by the increase of the rent by the municipal corporation. Now, but now the talks are going on, Lordship, and there is every chance that the incident matter will get settled, Lordship. Lordship, I am praying for some time, Lordship, because in the meantime, this matter will get settled. The talks are going on, and it Lordship, from rupees 5 per month to rupees 70 per day. Lordship, Lordship, I have not brought the file, Lordship. Actually, this matter is talks are going on in settlement. The last, no, Lordship. Actually, this matter was filed by some learned other council. Yes, Lordship.
Oh, bless.
Yes, Lordship.
Yeah. Exception, you know. Yeah, I record for you.
Item number 17. WPA 177 of 2022.
Lord, I filed
the report, my lord, because this honorable court has directed the deputy commissioner to conduct an inquiry with regard to certain case records which has been prevailing at Tahsildar. He has conducted an inquiry and not he has submitted a report. As regards to a case, revenue case, which is pending before the Tahsildar in the year 2001.
It has a
So-
bearing in the matter, Your Lordship. The list can be decided only when the record comes in.
So far as my lord, the Tahsildar has also submitted a report saying that that record is not traceable, and so far as the deputy commissioner, after conducting inquiry, he has also submitted a report that the record is not available. my lord.
Lord, the record is not there, maybe. But as a counsel for the petitioner, I know where is the record. Let me take an exception to the report, Lord. I can give the particulars and detail in the exception report that where record lies. They are deliberately withholding those records, Lord. Let me take an exception to the report, Lord.
Item 18, WPA 240 of 2022.
I'm appearing for respondent.
For the repetition, this can be taken up and it can be disposed of, Your Lordship. Lord, my
Decision of the decision.
my Lord,
Based on the documents available in the.
no, my Lord, the thing is, my Lord, my Lord,
Not an appellate court.
my Lord, Lord, the Lordship, palpably, the impugn order cannot be sustained. There are many grounds I've raised to attack. The first and foremost ground is the authority have taken the decision with a impugned order based on an order of this honorable court. My lord, if not looks into that order of this court, a coordinate bench order, not this court, upon point being urged by the adverse side, have turned down their points. My entitlement has been recorded. Upon recording my entitlement, the matter was relegated to the authority to take a decision. Not in view of the judgment of Supreme Court. But what this court has passed, not there are two kinds of order it can pass. Simplicity consideration to the authority, you take a decision in one or other way. That was not the direction. The second direction, no, I'll just show that. The point, the finding given by the authority, page 112, have been already decided. Page 112 by this court, it's an order dated 8th January 2020. I'll just place this order, my lord. May I take the pen to place it now? Lord. My lord. my point of argument would be, Lordship, any decision taken by the executive authority in derogative to the order of this court is nullity, my lord. The issue, rather the finding arrived at by the Deputy Secretary Revenue in the order impugned has been argued in this court in the previous round of litigation. And this court has accepted my submission. And my lord would see the penultimate paragraph of the order passed by this court at page 115. Two documents were directed to be looked into, and the finding has to be taken in view of the observation made by this court. Now, the authority says my father's names was not reflected. I have an scheme of 66 also in this writ application. The requirement is, my lordship, the entire land occupied by my father needs to be regularized. They did not do so. The authorities time to time recommended my case. The statutory register being maintained by the office of the deputy commissioner, that's Tahsildar, would indicate that my father's encroachment is since prior to 1966. These documents were not looked.
Not say encroachment. Therefore, the court will be able to say this that has not been accepted by the court. The order that you are relying upon, the earlier decision, the judge has emphasized and reiterated in the next case that why I am saying it's there is no acceptance of this issue by the government. But the court said no.
But the now authority takes a U-turn by the order impugned saying that those records are not available. Malad, I'll show that. Kindly turns to page 121, second paragraph. The documents submitted by the appellant were forwarded to the Assistant Commissioner's settlement for verification. After verifying the document, the Assistant Commissioner, the documents upon which this court granted me liberty.
He said with reference to the probable encroachment having been maintained under one register maintained under the 105.
My lord. My lord. But this is the document which I have placed before the authority, not this. This is their own record. I have an explanation. They cannot take a U-turn. Their own record I have obtained under the.
They have not gone anywhere that they have to take a U-turn. They have been denying it from day one. This court said that you have to consider the law. Why is it? I make it clear that when I say valuable right in this model, it only means valuable right. You can't say one.
Yes, my lord.
There is no finding in all as you are trying to make out that the court has gone a finding and then they had no option but to decide otherwise. It doesn't appear to.
But lordship, because the
Therefore, the court asked you, then you are arguing in the 226. Is the information in the process?
The decision-making process, lordship, the decision-making process is an arbitrary. It's especially arbitrary, my lord.
So what is the arbitrariness? What was the proceeding which was required?
Because the report which was called for, let's go with the situation what the authority says, lordship. They have relied upon a report of Assistant Commissioner. It was not furnished to me before taking this decision, lordship. It is adverse to my interest. If that be the case, if they say that. Now they say, lordship, while taking decision that the records are not available based on a report.
That document, that this is documents which you submit. They say we don't know this how the in our record. Regarding that 105, they have not denied that it does not register prepared under 105.
But it records the date, probable date of encroachment of my father's. Yes, my lord.
Said if not proved, then it's not enough.
But they have not taken adverse, but my encroachment was not shown to be a post 66 also, my lord.
They are not required. You are required to establish.
But the statutory documents which I have submitted, my lordship, if they accept that documents on its face value.
They accept,
My lord.
but they don't. They say that we are not agreeing with you because we have a very number of benefit under the 87 scheme. Claiming that 200 square feet in the urban area. You have relinquished any claim you may have made for a pre-1942 settlement. You say no, it was reported that there is a probable encroachment. The court says if true, you may assert not being able to.
Those register. But those register are having a legal sanctity under the local regulation, Lord. It's not that they simply say that
the review of the earlier reports.
Yearly report order has considered the registered declared under one. It should have noticed that it says probable input, which you have to do. So it has relegated you to the authority here. To cut short the matter, it's instead of relegating you to the DC, it has said go directly to the secretary. When you are not arguing an appellate jurisdiction. That is all been heard, and the six complied with orders based on material, whatever was there, the insufficiency of the field is not a ground under 226. There is no procedural impropriety that was required to be complied by any set of rules which have been calculated. But the official records could indicate that my father remained in possession after his death. I am not looking into that. But the authority have not considered these material. It's a relevant material to be gone into. Which material you have brought before them? Show from your application what are the material you brought. My lord, I'll show those two documents once again. I'll show those. After the High Court related to my lord. To decide what an application file earlier or an application file subsequent to the High Court. But no application is pending. They have taken a decision based on a direction of the court. There was no application pending. Only the proceedings are not given effect to. My lord. Must have filed an application to again given. Just to bring those records on. Where is that? My lord. At page 117. In the form of written notes and all the documents were relied before the Secretary Revenue. Lord would see every documents, Lord would see at page 118, which was part of the writ petitions were relied before the authority for their consideration. Page 117 and 118. And those documents are part of the present date applications also. The recommendation mooted out, the time to time letters, internal communication between the authority to consider my case in terms of the 66 schemes. It said that there are earlier applications pending, but the first application was very good. You say that I have filed in 15 and 16, but all that has been stated in 90s. Page 83 is the last representation, 2008. Then 2010, this court was approached for simplicity consideration. Say that all matters are pending since 2010. My claim was not turned down, it was kept pending. So I've been pending from 50 to 2008. Papers are there. Not see their action taken on my representations. Mine. For 118, last 4 lines. The appellant rely upon each and every document, including the pleading, which do form part of record of WP number 96 of 2024 and the valuable right of the appellant for regularization has been declared by the Honorable High Court with a order dated 8/1/20. All the writ documents, those are part of the present date application. I'll just show also one. No. That writ petition is not a part, only the order has been answered. Yes, madam.
Probably it is the same, it starts from page 38.
Yes, madam. My lord, would see, I was under the legitimate expectation, my lordship, that my case is under consideration. They never turned on my claim, lord. Last representation was made in the year 2008, when nothing was done. Then for the first time, 2010, the first writ was taken out. And my lord would see right from page 38, each and every correspondence would indicate that my case is under a positive consideration under the 66 scheme. Reports were called for, internal letters, every document, show cause. That is true, love. That is true, love. But I'm not the Lord. Lord. This is the letter dated 29/10/1960, Lord, of the Deputy Commissioner. At page 42, Lord. It's addressed to my late father. Lord would see, this has been issued by the Deputy Commissioner. Lord would see, with reference to an application dated 10/10/60 for grant of house site at Quarry Hill, I am to inform you that your application will be registered in this office. The application will be considered when house sites are carved for allotment for house building purpose. Further note that you have constructed your house in the site only in the year 1958, and you will be getting the priority on allotment only according to the same. So they've acknowledged my father's occupation over the subject and since from 1958. Then comes page 43, the statutory 10/10/60. Not at page 41, annexure P3 of my late father to the Deputy Commissioner.
Something is under the Workmen's Compensation Act. This is not an enforcement under the settlement procedure provided under the Andaman and Nicobar L and L or whatever.
Lord, kindly see the penultimate paragraph at page 41. It is therefore humbly the petitioner humbly privileged to refer his representation dated so and so and subsequently reminders dated so and so regarding for allotment of his encroachment of paddy and hilly land bearing survey number 1699, which he was encroached in the year 1939, but the same has not been carved out by the Revenue Department. And subsequently, after long discussion with the Deputy Commissioner, Andaman Nicobar Island in his chamber on 28/9/1959 by Sri K.R. Ganeshan, trade union leader, Netaji Hall, Port Blair, and it is understood that the matter is denied. Further, the sick and handicap of family man is always affected in the major accident occurred when he was working in West Indian match factory and was already dead by then Deputy Commissioner in the period of 1945 to 51. His untold hardship and poor condition, his case may be pleased to allot in favor of the said encroachment.
But for some order, you are seeking some benefits because of some injuries sustained in your employment under the Workmen's Compensation Act. In lieu thereof, you are gaining some benefits. Not relevant to the.
Lord would see the last paragraph. It is therefore humbly a request to competent authority, Deputy Commissioner for Andaman and Nicobar, to look into the matter personally and use for his good office for allotment to the incumbent like the same provision made to the others. I have just compared, Lordship, that other were given benefit, just extend the benefit to them.
Under the work. Under the provisions of, now that you are claiming under the provisions of LR and LR, whatever it is. And maybe and then. For now, secondly, you are compare and say that all the application with physical LR and LR.
My father was an encroacher, Lordship. I'm just, my specific and concrete case is my father Mayappan was an encroacher. All correspondence, so long he was alive, he was made. Authorities have issued letters in favor of my father Mayappan. Under the scheme, Lordship, before the allotment is effected, if he or she dies, then his descendant is entitled to get benefit. Ganesh, my lord, my lord. My lord. But these reports are adverse. These were not given to me, my lord. This, he is not that gentleman. This thing is coming for the first time in the order impugned. To demonstrate that I'm not that gentleman in whose name the record has been maintained. My lord, see that record of 57, it records my father's name, Mayappan.
Yes, we have filed an opposition. One 105.
Register meeting under 105. Okay. Regarding with the secretary as referred at page 121.
Page 48 of their opposition. Page 48, R7. M. Ganeshan, son of Sri Mayappan. 58 encroachment. Page 48, R7. Lord would see the remark column, the first two columns pertains to the name and details, survey numbers, and the last remark column is the date when the father have encroached. Same M Ganeshan, M. It is not carries no deed, but they have relied upon it.
Even after coming to the court of the 78, much later.
It is their own document, so they cannot.
Therefore, they say that it is doubtful, it is not something contemporaneous to 1958 that it can be relied on. It is a claim which you say when they are conducting the survey, sometimes perhaps for implementing the 87 scheme. Say it is same picture, say we don't need it travel. Therefore, this is it's not a contemporaneous document. As reference to dates of 1978, the body itself.
The proving of this document, Lordship, their own document, I'm just placing to that, Lordship. It's not like a civil suit where, Lordship, inquiry I can at best place the records. They have to compare the records with their own record. That has been done. So they have brought this R7 on record by way of opposition. They have to admit, Lordship, R7, yes, page 48. There, my father's name, my name's recorded, my father's name recorded, the date when my father encroached, that has been recorded, and it also indicates that under the 87 scheme.
Not record what you claim during this. It records your claim during a survey conducted much after 1978.
My lord.
It does not record any provision which they accept. It only records your claim.
But this has to be read in consonance with the documents that is statutory. That has to be read with in isolation. It can't be their own records. That records my probable date of encroachment, Lordship. If both documents are correlated with each other, Lordship, one thing emerges, Lordship, that my father was an encroacher since prior to 1966, 58. Government land, GOBT.
This enforcement
Happy.
come up in 77. And the case was registered against by serial number 84, which was removed on 4 September 1978. Again, he has included the settlement during October 78, which was reported on 17/17. The case is pending for further action. If you want to accept this, then it's not in any way rectifying or verifying the
So
issue.
let me use my reply as against this opposition in such case, Lordship. These documents comes in, then let me use my reply. It is their own document, Lordship. It's not my register is something else. Lord would see. Kindly turns to my writ petition. I'll show that. It's at page 43. Page 43 of the writ petition, annexure P4. Page 49. These two documents may kindly be seen, Lordship.
Have made it to be registered.
My lord.
Which register?
Page 43. Page 43. Encroachment register page. I'm not see at the top. See, rule 105. Register of encroachment on government land. Page 43. But this not here.
Much later to what the clarify this is now more important.
But encroachment register are not maintained every year, Lord. Once record is made, it would be issued as and when applied for. It's not that every year the record would be maintained, Lord. So once the encroachment rates records.
Column 7, this has been considered by the
28/12/1957, Lord. Probable date on which
the date the court said
the proving has just to place their own documents which are procured. I'll use my reply, Lord. Use my reply.